making some time today to hear what we have to say here about the tax issues that are raised on the onset of setting up U.S. business operations. So what we're going to do here today is I'm going to share what I typically see when I have foreign companies or individuals looking to set up operations, business operations in the U.S. So we're going to talk about three main keys. But before we get there, I wanted to share with you really what is the key to making the 3 steps work well for you, and that is it's all about commitment. So here we have a quote by Peter Drucker. So unless the commitment is made, there are only promises, hopes, but no plans. And so where I have seen the stepping off from a foreign country into the United States fail is that one word, commitment. And it takes a lot of time and planning to make certain that you have considered as many factors as you possibly can to get yourself off on the right foot. So when we're looking at inbound planning, our focus today is going to be on the planning and the commitment and those 3 areas where I see a lot of issues. What we have is we will in future presentations talk about how we go about enhancing profitability, expansion, M&A, acquisition type topics. We'll talk about the repatriation strategies back to the home country, and finally disposition. Basically, we're going to talk about the life cycle of a corporation coming into the United States, setting up an operation in the United States, and we're going to discuss the cycle and the tax ramifications of it. So what I see first and foremost, the first conversation I have with anyone looking to step into the United States, it is these 3 areas. It starts with talking about the operating model, then the supply chain, having a tax efficient global supply chain, and lastly, talking about with the foreign corporation mapping of transactions. So let's start real quickly here with the operating model. What I see a lot is companies go, well, we think the U.S. is we think they have, it's the biggest economy in the world. We think our product or our services do very well there. Our suppliers want us there. There is some reason as to why they want to come to the United States. And what I try to stress for them to think about is to think about how they are thinking about their operation. How are they going to operate? Because let's use, for example, if we're in Germany, if we're headquartered in Germany to set up an operation in the United States, how is that going to tie in to our overall business operations? Are we going to sell parts? Are we going to sell finished products? Are we going to license intellectual property? How does all of that tie into what we're trying to accomplish from an overall global perspective? And what you'll find is for a lot of foreign companies coming into the United States, they're going to be part of a group. Typically, they're part of a group. And with the group comes other operations around the world. And so again, is to get people to step and take a look at their business plan, the operations, the business plan, and how does this opportunity to come to the United States, how does it enhance the ultimate goal of the global organization? And one thing that I think is very, very important is to remind your clients that once they are here in the United States, they need to review that operational structure, the business on a basis. We've seen a number of major changes worldwide, starting with the base erosion, profit shifting. We had the Trump tax reform. Those were 2 major items that truly impacted global business, and this is happening all the time. So we really need to make sure that we look at this, at our business on a regular basis. So if we move to integrated chain, what a lot of companies miss is that they miss taxes within the primary functions of a supply chain, which is procurement, logistics, operation, and market channels. Those are components of an integrated supply. On the left-hand side, you have your suppliers, and on the right-hand side, you have your customers. And so it's that whole process of how product is sourced, how it's manufactured, how it's delivered, both from a supplier and to the end customer, and that relationship with the end customer, sure that you have proper returns, have your fingers on the pulse the client wants. The reason why the chain is so important, as we've seen with COVID, there has been major disruptions with supply chains. With that, there has been tax that has likewise impacted supply chains. One of the biggest ones was some of the tariffs that the Trump administration had put in as it related to both steel and aluminum. It had major impact on the industry. You need to be aware of the type of item as they impact the supply chain. In particular, we want to go in and we want to take a look at items as VAT or sales tax. We want to go in and look at property taxes, real estate taxes. We want to go in and take a look at this to see, based upon how the company, from a supply chain perspective, if there is an opportunity at set to make some critical decisions going to help the company enhance bottom line. Lastly, we spend a lot of time talking about mapping. And people say, well, what do you mean by mapping? By mapping, I'm saying step back and take at all of the transactions that are across a border. Whenever a transaction crosses a border, especially U.S. perspective, but it applies likewise to the to many foreign countries, we're dealing with, especially because we're dealing with related parties, we're dealing with transfer pricing. And in the United States, there are some significant reporting requirements as it relates to transactions between a U.S. entity and its foreign parent or brother sister corporation. And you'll see on the slide, I have listed the primary items you see that need to be mapped: the sale of inventory, services, debt in the form of interest payments, rents, royalties, and again, services. So we need to be aware of where are these services coming from, who is providing them, where is the IP being licensed from, whatever it might be. We want to look at those cross-border transactions because there's tax ramifications in that. I'll give you a good example. I was dealing with a client. We were dealing with a Colombian client that wanted to do business in the U.S. And in doing business in the U.S., we looked at, we don't have a treaty. And most of the payment of the debt payment going back, it was going to be from the U.S. to Colombia. Well, we don't have a treaty, so the withholding is the 30%. By stepping back and looking at what their goals were on a more global basis, we were able to set up an intermediary in Spain using their ETVE program, and we were able to get that payment going through Spain back to Colombia, U.S. to Spain, 0% withholding, and I believe the withholding from Spain back to Colombia was something like 5%, something very small. So that's why you want to map transactions, because once you cast an entity, it typically, whether you go for partnership or corporation, whatever it might be, once you cast that in that form, it's difficult to change without a possible impact. So the first choice in coming to the United States is this whole question of what entity do I select? And I can tell you that I see it over and over again where an advisor is not given all the facts up front, and they will often make an assumption that this is the right entity to use. And so we want to be very, very careful with that because, again, it costs time, money, and it could cost you taxes in setting up the wrong entity at the outset. So there are basically 4 different ways we go about this. Typically, we see a foreign corporation sets up a U.S. corporation. Pretty straightforward. We could also have a foreign corporation set up a U.S. LLC and check the box to be considered disregarded. I actually have that with a Australian company. They have 2 domestic LLCs, each performing different functions. They've checked the box and to be taxed as disregarded. So it's basically the Australian parent corporation is filing a U.S. return. You also see just a pure branch where it is the foreign corporation doing business in the United States. You'll see that quite a bit too. And then lastly, we see the partnership structure. The partnership structure has lots of variables to it. You could have it with just individuals, other partnerships, other corporations, other special purpose vehicles. It's typically used when we're talking about investments with like PE companies. You see a lot of this. So again, the question here is, what is the best entity for me? And you have to look at the tax ramifications of getting money in, the tax that is going to be paid from an operational perspective in the United States. You have to look at the withholding taxes that might be applicable for licensing or whatever the cross-border transaction with the foreign parent or its brother sister's corporation to the U.S. What is that going to look like? What's that going to cost me? And then lastly, you got to look at repatriation. What is going to be the cost of repatriating a dividend? Interest payments. Again, transfer pricing in the international realm is probably the area that's driving a lot of taxing authorities today because they're all looking for their piece of the pie. So again, in taking the step of looking at the right entity, it is important to be upfront with the advisor and to know you have several different options and to model the taxation of each of those opportunities. So let's go to this one. The second item that I often see inbound companies struggle with is this maze of state and local tax considerations. And a lot of them appreciate that we have 50 states, but they don't often recognize that the 50 states are not similar. They're very, very different. So when we look at the income tax side, we're focusing primarily on 44 states in the District of Columbia that have some kind of income tax. There are 4 states, Nevada, Ohio, Texas, and Washington, that have some form of gross receipts tax. And then Wyoming and South Dakota have no income tax at all at the corporate level. And so understanding that variable when you go to set up in the United States is extremely important. And you can have a situation where you might not have income tax liability but a sales tax liability. And that's what we're seeing trips a lot of bound companies. They look at the income tax side, they don't think about the sales tax side. And one, as everybody knows, I think it was June 8th, a couple of years, Wayfair decision came down from the U.S. Supreme Court, which basically said, hey, look, this is what happens now. Do not have to have a physical presence state to allow that state the right to tax your activity. So with that said, all of the states have in some way, shape, or form had to adapt to Wayfair. And many of them have set thresholds on the number of transactions or the amount of gross receipts that may trigger your need to file an income tax return where you never thought you had to in the past. So while you may look at the traditional nexus of somebody doing business in a particular state, you now have to consider other factors related to states that might require you to file a sales tax return. And the compliance is something that a lot of people just get overwhelmed with. If you are an internet-based business and you're selling through your platform and you're selling to the end customer in a number of states, you have a pretty huge tax liability process that's going on. I think what you'll find is a lot of people will go through like Amazon or Walmart. They'll go through one of those operations, one of their web-based platforms to sell, so that the collection of sales tax is on them, and they just remit it on your behalf and take the cost out of the proceeds that you would receive. Another thing that a lot of people don't realize is that the United States has close to 5,000 jurisdictions that impose some form of local municipality, county type taxes. Ohio and Pennsylvania are notorious for this, but there are many, many other states that likewise have a corporate level tax. So you want to make sure that when you're thinking about income tax in particular, you income, corporate income, you look at use, and lastly, you look at local to make sure that there's nothing there. This all comes into play when we're talking about the opportunities with credits and incentives. So credits, we won't spend a lot of time talking about it, but incentives are very, very important, because incentives give the states the opportunity to attract foreign businesses to their location. So for example, in the state of Georgia, I'm sitting here in Atlanta, in the Southeast in particular, this is the automotive hotbed of the United States. It used to be in Detroit. It's now here in the Southeast part of the country. There are thousands of auto suppliers, all owned either by European or Asian in the Southeast, that were attracted there via a lot of business development and the provision of incentives to settle in Alabama versus Georgia versus South Carolina. So you want to keep that in mind. And then the last one is the other taxes that could be out there: property, intangible tax, etc. Again, it is coming into you're looking at the overall operations and saying this is where you might want to go here, and here's the cost. And the last thing I want to talk about real quickly is compliance. To get the compliance right at the outset. I'm dealing with a situation right now where a foreign tax is filing a partnership return. They are a foreign eligible entity. They did not make a check the box election. They are a corporation. They filed as a partnership. They've missed the date to file a late entity election on Form 8832. And so now you're talking about a PLR to get permission to extend the time. You're talking professional fees and IRS to file that. Forms that you see at the here, the SS, the 8832, those are the first two forms I work with. Let's get either I do it or in conjunction with their attorney. Let's make sure the EIN is taking the 45 to 60 days to get EINs issued. The 8832, am I going to be a corp, a branch, a partnership? What am I going to be? And then you get into the actual tax returns. The one I want to mention to pay attention to is the Form 5472. We talked about that at the very beginning about mapping of transactions. There is a $25,000 penalty for not including that form with your U.S. tax return if you have cross-border transactions. So it's very important that you pick that up. And the other one that's very important is the W8BEN, W8BEN-E, which is basically the foreign parent gives the U.S. company the form, basically saying, hey, look, we're taking advantage of the U.S.-Italy tax treaty, article, whatever it might be, and the withholding tax is 5. It's not 30, it's 5. And so while that's not submitted to the IRS, it's important that they keep that in their records in the U.S. because the U.S. is the withholding agent. And just real quickly, I'm going to end on this slide. This is basically the strategy that I use in helping companies. So it's real about these areas: the tax efficient supply chain strategies, transfer pricing, global mobility, movement of people, VAT, GST taxes, and then trade and customs, and that's all surrounded with compliance. And so if you have a situation where you would like a consultation to talk about that, please give me a call. I'll be glad to help you. I do this all the time for local attorneys and accountants all the time in helping them find the right path. And then last but not least, keep in mind that, again, if there's there are only promises and hope, but no plan. So planning is the key. And with that, I'll turn it over to Gary. Brian, appreciate it, gentlemen, for giving me the opportunity.
What we wanted to do in this presentation was to give you a flavor, because we had such little time, with respect to a foreign company coming in to do business in the U.S. And it's obviously outrageously complicated in terms of planning with respect to the income tax. And that's what we wanted Jim to go through. Honestly, we really only deal with a handful of CPAs in the country that do this, because it really takes a disciplined approach where you work through these models to break down exactly what kind of format you want to enter with. Under no circumstances should you enter without the planning. It's just a mess. So we really rely in many cases on the compliance by the few CPAs in the country that can really handle that, and Jim is one of them. We've known Jim. He was with a large firm before, and now he's just handling this kind of as a boutique, and we really appreciate his input. I thought it was exceptional. What we're gonna talk about is you have the business, you have the business operations, you have the potential branch in the U.S., whether that's a corp, whether you're a partnership, whether you've got other people involved, whether you're distributing or you're selling here. Those are income tax issues. We also have the issue, it just invariably comes up with, okay, what if we've got a really big company, maybe the owners don't come over, maybe the officers and directors come over, maybe it's a smaller group and the owners come, and maybe the owners may want to stay permanently. You know, that's never happened before. So what we want to get into is kind of what happens, let's see here, on the pre-immigration kind of, well, maybe we'll stay, maybe we won't. Let's do a little planning. You're not going to believe this, but this usually gets missed. So it's better not to miss it, at least to discuss it. So at least when they get with, because they will get with a lot of times independently, immigration counsel, and for whatever reason, if they're not with someone like Jim or whoever we're using on the compliance, the income tax compliance side, they won't pay any attention to the issue of maybe I'm going to stay, maybe I'm not, maybe I'm going to stay for 8 years and then leave, but I want the option. There's a lot of things to think about with respect to how you're going to handle that. Brian and I will go through kind of a broad brush. We've got about, what, 20, 25 minutes to hit the issues that should be considered. And then we'll probably do a few more seminars on this with Jim in terms of, again, organizing some of the details on the income tax side and then integrating the details on the immigration slash I'm going to work here and leave side in future webinars. But as you look at the agenda, you kind of have to understand, well, how does the U.S. estate and gift tax work? You know, how does it work for a U.S. person, meaning a person who's a citizen or a person who has come here and wants to stay? I know that's it's like, what's in their mind? I know it sounds idiotic, but that's actually the standard. What's in their mind? Do they want to stay? And so that becomes an evidentiary issue. Like, did you really wanted to stay? And they said, no, I never intended to stay. And you get into that, whether or not they're a resident. Because when they become a resident, they're taxed worldwide on all their assets in their estate. If they were to die here or they make gifts here, it's very, very significant. So that's the estate gift. We'll get into treaties. Jim touched on income tax treaties. Well, there's also estate and gift tax treaties. And then there's some strategies some specific strategies we'll touch on both before they come in and after they're here in terms of estate and gift. Let's go to the first slide. Of course, I'm going to have to use the mouse here. Yeah. The general idea is we don't want to bring assets. If you're foreign and you've got the foreign company and the foreign company is going to create a branch here, we don't want, if you're going to move here for a while or maybe even permanently, the last thing we want to do is bring your 200 million or your 2 million into the U.S. and then be subject to the estate and gift tax. There's a lot of strategies to avoid that. There's no reason to do that ever. The only time we get into that, just as an aside, is if somebody for whatever reason focused their let's say they're from Venezuela and they focus their investments in the U.S. Well, sometimes there's a reason to become a resident in that non-residents, we'll hit on some of this in a few slides here. Non-residents don't get much of a credit in the U.S. for what they have in the U.S. Whereas if you become a resident, you get a huge credit this year. That may go down next year. But sometimes we just want to get the huge credit. So we become a resident because all the assets are here. Let's see here. Okay. On an overview issue, so you, as a resident or a citizen, you get this huge credit, 11.7 million, each husband and wife. It's never been that high. And they can give away, whether they're foreign or resident, 15,000 a year. But if you die and you have this taxed, it's a 40% rate. And that applies to the resident who gets the huge credit and the non-resident who doesn't. When do you become a resident where everything that you have is subject to the U.S. estate and gift tax? Well, I just touched on it. When you intend to stay, you're here and you intend to stay. Note that the income tax, which subjects you to income tax on whatever you make worldwide. So if most of your money, for instance, if you're an executive, you come over here and you become a resident, you're making most of your money in Argentina, you'll have to pay U.S. income tax on that money if you become an income tax resident. But the standard is not, I'm here and I intend to stay. The standard is a much more complicated standard. It's basically a more objective standard. I'm here more than half the year, or I failed the substantial presence test. Most of the people coming in, our seminar is not about income tax. Most of the people coming in go by the cocktail rule test, which is, I can't be here for more than 120 days a year. They all focus on the 120 days a year, but the substantial presence is a little different. It's a weighted average of the last 3 years. But if you're not here 120 days, you will pass the substantial presence test. None of that has anything to do with the estate and gift tax. So a lot of people, when they come in, they say, no, I'm not a subject to this, right, Brian? I'm not a subject to estate and gift tax. I haven't been here 120 days. It's a totally different law. It's a totally different type of tax and rule. Why don't you go into the worldwide assets and the difference here, Brian?
Gary's already hit on some of the high points, but basically, once you become a U.S. resident for income taxes, that's one rule, and that is it subjects your worldwide income. So usually that's either by the green card, your legal residency, or the substantial presence test. That's on the income side. That's subtitle A of the code. Subtitle B is estate and gift and transfer taxes. And that's based on once you're considered domiciled here, which is physical presence and intent to remain. At that point, your worldwide assets are taxable, subject to the tax, no matter where they're located. And so that's a very big deal if you decide to immigrate here and you haven't done any planning and you have substantial wealth outside the United States. All those assets now are put in the estate tax net, and you have to deal with it.
And what happens, Brian, if we're here, like an executive comes in, they start business here and gets a green card, wants to work here, and he or she is here for 8 years under the green card?
Interesting. There's a test for long-term residents under this area of law, and if you're here for longer than 8 years, 8 out of 15,
right?
So it's not just 8 in a row, but 8 out of the last 15 years. Then there are 3 tests that they look at. One is your average income the last 5 years, which is for, I think under current law for 2021 is 179,000 in the weighted average for 5 years. If you have more than 2 million in assets, or if you fail to file the right tax documents when you expatriate and leave to go back home, then they pull you in, you're a covered expatriate.
But then once you're covered and you want to go back, you want to give up the green card, there's an exit tax.
It's a deemed sale of all your assets worldwide.
We're going to end up going down these little paths. That's actually an income tax. It's not an estate tax, but it's like an estate tax. But on the other side, there actually is an estate side of that called the inheritance tax, where that person who leaves is not going to be able to give assets back to someone beneficiary in the U.S. If they do, then the beneficiary has to pay tax. It's very complicated. But these issues have to be kept in mind. Maybe we'll do a seminar on that, actually, the executive coming in.
Right.
You know what I'm saying? But this, in general, that's what we're looking at. You're going to start your division. What about the people coming in? And then, you know, we go into some other big pieces here. U.S. people, citizens and resident non-citizens, you can give between spouses. There's no tax. Okay.
If you're a citizen.
If you're a citizen, oh, that's true. There's actually a funny rule. Even if you come in and you're both husband and wife are residents, if you're not a citizen, you only get a very limited amount of freebie each year on for gifts between spouses. And also, if you die and you leave to your non-citizen spouse, you have to do it in a special trust. We're still on. Okay, here's the non-resident.
And the big thing here is, at least from the broad view, is if you're a non-resident alien for estate and gift tax purposes, you only get a $13,000 credit against your tax, which is basically $60,000 of U.S. property that's shielded from the estate tax. Everything else above that is taxable at 40%.
So even the most simple, what would be considered the most simple acquisition or financial move by an executive moving in, we had some people move in, simple move. Oh, we bought a house for $4 million.
Story.
No planning, didn't seek any guidance from anyone. And mom dies. And the house was in their own names. There's no credit. There's a $13,000 credit. So with the IRS, it says, well, $4 million, we're going to split that down the middle. There's no portability. There's no movement of credit between husband and wife if you're not U.S. people, and $800,000 in tax on a $2 million, on a $4 million home, $2 million estate. Nothing they could do. That was a very easy thing to avoid. Just a good example of the mistakes people make.
And that can be avoided by an easy planning technique, which is, Gary?
Which is a foreign entity. You just own the residence in a foreign entity. It was kind of ridiculous. Those people never became residents.
They were
that would have been one of those where maybe they become a resident so they get a bigger credit, but they actually had never become a resident, so they didn't get the credit at all, and they got whacked. That was very easy to plan for. Interestingly, on this next slide, intangible assets, you know, the non-resident, non-citizen can give freely.
During their lifetime.
Even U.S. site is intangible, but if you die with that intangible as a non-resident, non-citizen, so these are the executives who don't come over and don't say, I'm going to stay here, I'm leaving in a year, or whatever the status is. They're going to have all the stuff they buy in the U.S. is going to create a huge tax if they die, or with gifts. But not intangibles. But if they die with the intangible, it is subject to estate tax. So the idea is to get U.S. intangibles out of the U.S. estate tax.
Which is also interesting. And this is on a focus on the income tax. The sale of those assets, especially if they're stock, for the non-resident, non-citizen, is income tax free.
Mm-hmm.
But if they die with it, you probably have a disaster, because you can only get it.
It's crazy.
Yeah. So there's just some unique rules here. What's interesting though is U.S. currency is not intangible.
Yeah, everyone thinks that it's intangible because it is. I mean, it's a promise to pay this amount. It used to be backed by gold, but you know, the gold's, you know, if I give $1, it's the U.S. government saying it's worth $1. It's intangible. It's a promise, but not according to the IRS.
For estate and gift, it's not.
For estate and gift, you want to give cash abroad.
So this slide here just goes over some unique types of assets, their characteristics, and how they can affect the gift tax during life.
Yeah, this is for non-residents, non-citizen. You've got to roll the thing.
Oh,
yeah.
Sorry about that. Treaties.
Treaties can be great. Jim hit on some of the advantages of treaties. The whole idea with treaties is that you've got income tax treaties, which is what Jim hit on. So that might eliminate withholding, I think was mentioned. With estate and gift, you have a separate estate and gift tax treaties. So they're either situs or domicile. Situs means that the country where the asset is located taxes the asset upon the death of the decedent, right? So if you have, for instance, non-residents, non-citizens of the U.S. and they want to buy stuff in the U.S., why not just avoid the issue totally and create a foreign entity that owns assets in the U.S.? Most people ignore any kind of counseling and they actually come in later. I know it sounds crazy. We probably more people come in with problems than they do for planning. I'm not sure what the motivation is or whatever. But so then you go to, okay, is there a treaty that eliminates the estate tax for this person? Are they from a country that has entered into an arrangement with the U.S.? Situs means that if the asset is sitused in the U.S. and they're from France, does the French treaty say, okay, U.S. will tax it, France won't? The French treaty actually doesn't say that. I'm just using that as an example. But you want to have a treaty that says only one country will tax it and everybody moves on.com. That's a situs treaty, no double taxation. The problem with situs treaties, and they're hardly ever written anymore, is that the U.S. may say, well, wait a minute, all U.S. corporations are sitused in the U.S. And Germany may say, well, we don't define situs like that. We say situs is where the certificate is. So now we have a situs treaty regarding corporate stock, but we don't have a situs definition that's uniform. That used to happen all the time. It still does. There's still some situs treaties. And you have to kind of work that out by planning. You could get caught still. I mean, a lot of times you'll have to be subject to double taxation. Sometimes if you are with a situs treaty issue, you can get a credit. If you pay tax in the States, on the corporate stock, for instance, you may get a credit if you also pay tax in Germany. The problem with the credit is you'll almost always pay the higher tax. Domicile treaties are a little bit different. they work with respect to that domicile. Domicile is that idea of I'm living here and I want to stay forever. I want to live here and I want to die here, basically. And domicile treaties say, if you're domiciled in France, France will tax you on all your assets. If you're domiciled in the US will tax you on all your assets, and you won't have to deal with the country of citizenship, just with the country of domicile. And that's a lot more simple because we don't have to go tracking down all these situs issues. But that's treaties in a nutshell. We're trying to do a little broad brush because we're going to run out of time. Yeah, here's some examples of the situs and domicile treaties. You know, pick your country. A lot of times what we do on the income tax side is what Jim had mentioned was we do pick. We kind of try to run things through these different countries. That's becoming much harder. That's becoming much harder. You know, we have a lot of the audience has heard of like this idea of inversion, where the U.S. has now moved headquarters offshore. There's now all these inversion rules. There's these rules associated with proving that you may be actually doing business in a certain jurisdiction. You can't just say, set up an office there and run everything through there, like that note that Jim was talking about was run through Spain. Some of the U.S. side, they don't really respect that. But the idea is that in estate and gift, you can definitely take advantage of treaties if you plan right.
And if you're a non-resident alien who is thinking about coming to the United States to establish their residency, there's some things you need to think about before you come in. And a lot of this is, especially if you have non-U.S. situs assets, remember, once you obtain your residency, at that point, you cast a net over all of your assets worldwide. And so there are planning strategies to get these assets outside of the estate tax net before you come in. The easiest one is just to make gifts to family members outside the United States of the non-U.S. assets. A lot of times that works, sometimes it doesn't. The other option, a lot of times, is to create a foreign trust before you come in, and you put your non-U.S. side as assets in that trust, and then
or your U.S. intangibles
as well, before you come in and get your residency start date, when you're officially a resident. And it's important though, because once you're here, unless you leave, you can leave at times before the 8 years is up. Once you're here, all that stuff is part of the estate tax net if you don't plan accordingly. Now, there's an income tax thing we'll talk about here in a minute, but right now we're focusing on the estate and gift. There are two different regimes, and we'll explain here briefly how at times, even though you might be able to get these things out for estate and gift, there could be an income tax ramification at death.
And sometimes you don't want to get it out based on that income tax issue. It's pretty complicated.
It's very complicated.
We'll just leave you kind of confused. That's kind of the goal of this seminar. That way you can hit the issues.
And the other would be is obviously if before they come in, they can always sell the assets in the foreign country before they establish their U.S. residency. But again, the cash itself, if they move in with it, it's going to be part of their estate and gift tax. Assets. It's important. The big thing is that the United States decided to impose a rule that if you utilize a foreign trust and before you come in, that there's a 5-year look back rule. And the idea being that it might be out for estate and gift, but we're going to impose a deemed sale income tax wise on all the assets inside that trust as if you funded it on the day that you came in within that 5-year.
It's like an expatriation of assets.
Correct. Now, that is postponed if the person who created the trust becomes a U.S. resident and there is a U.S. beneficiary of that trust. It becomes a grantor trust during that time frame as long as that grantor is alive or there's a U.S. beneficiary.
Yeah, what that means is it's disregarded for income tax purposes. It's disregarded during life. If you have someone come in who had formed a foreign trust, funded a foreign trust within 5 years, they come in, no, we're going to deem it as if you just funded it you're U.S. and if you've got a U.S. beneficiary, it's disregarded for you. So nothing happens. It's just looked at, it's just like the grantor. It's just like the funder. So if any income is earned, it's just like the funder earned the income. But there's an implication on death.
Right. So we discussed the 5-year attain. Now, a lot of times when this is done, there are ways to avoid this deemed sale when the U.S. grantor dies, or the earlier of that, or there's no more U.S. beneficiary for the foreign trust. So one way to avoid this would be to domesticate the foreign trust before the grantor dies.
Yeah, so before you came in, you got the assets out of your taxable U.S. estate before you had one. You were not a resident. And you said, you know what, I may or may not become a resident. I'm going to move my foreign assets, which are not subject to the net of U.S. estate and gift tax, and maybe my intangible U.S. assets, which are also excluded, to a foreign trust. They're out. Estate and gift tax wise, they're out. What you have to grapple with is if you come in within 5 years, after 5 years, there's no issue. But within 5 years, of course, all the clients come in within 5 years. Because there's no planning, so you can start to do planning at the end and get it out estate tax wise, and then the client comes in. Okay, it's grantor, it's disregarded, right? But what we don't want to have is this upon death, it's deemed, all that stuff is recalculated and deemed sold again. So the IRS lets you say, okay, we're gonna say no, it's not a foreign trust, it's a U.S. trust, and then you avoid that.
Now, when it's domesticated, all future income is going to be taxable in the United States, but you don't have a deemed sale at death.
Right.
Of the assets.
Right.
So, but it works for estate and gift. If you go to certain states, it can never be taxed again. Under the laws, basically, I mean, it's unlimited.
Right now, it can be never taxed again. Right, under the current law, that may change.
As long as it's in the trust.
But and also, if you've got the U.S. beneficiaries anyway, the U.S. taxation issue is not that heavy.
Right. So push it out every year.
Big issue, yeah. That's it. That's the wrap up.
That's really the wrap up there. So there are a lot of planning opportunities, but this has to be undertaken before they establish their residency. That's really the key. Once they're here
and want to stay here,
they're here.
Yeah, it's an evidentiary thing. Obviously, everyone's going to say, "No, I didn't intend to stay." When they have the mansion, all the kids are here, even the baby, and 6 kids in college, and they're basically sold their house in Argentina. It's going to be tough to argue that they didn't intend to stay. What happens is, you're not going to believe this, but not all the clients who have substantial wealth want to just move everything into a foreign trust for everybody, for all the kids. So what they do is sometimes they could retain 20 or $30 million or whatever that number is. Then we just move they become a resident, and we do domestic planning. And while it still exists, we like the GRAT, and we like some of these other strategies in terms of moving assets out of the estate domestically. This is just a domestic move while retaining an annuity. Because at this point, a lot of these people, at least half of the people really are at a point where, look, I need X per month. A heavy spender or what needs $200,000 a month. Some of the grandpas, like, he's got a fortune, but he needs $12,000 a month. Or $5,000. It's incredible. It's incredible. So it just depends on the person. But the idea is, if you can move assets out and pick an annuity period that you retain, that's reasonable based on the age of the founder of the GRAT, which is this trust, you can move a lot of assets out, keep the annuities. They spend the annuity, so it doesn't become an estate asset, and you've gotten the rest, the stuff that's not in the foreign trust out. That's kind of the GRAT.
Right.
You got to outlive it.
You have to outlive it, or it's hold back in, and then of course the remainder men are likely to be family members.
Oh, sure.
So
That's more on the GRAT. And anyone who wants to program, we could send you the program, the slides, or I think we also may have an outline. Also, we've got a couple of books on estate and gift tax for the non-citizen. I also wrote a book on asset protection, which anyone who's listening can just send us an email on. This outlines the details of the GRAT, why they work, that you have to outlive the term. I don't really want to keep people too long. I know it's exciting. But I know how people have to get back to work after the break. Brian, why don't you go into the QPERT, the qualified personal residence?
So one of the other vehicles that's very effective, and especially when these individuals that come here and they buy these mansions, is to utilize the QPERT, which is just sort of the idea is the same. They create this irrevocable trust. They put this home in it, or their primary home or a vacation home. You can have two. And then they retain an interest to reside there for a number of years. And that reduces the value of the gift substantially. Yeah. The longer the term, the more the discount. They have to outlive the term, but basically if they're able to do that, and then once it's over, you can kind of double dip. They can then pay fair market value rent to the trust to stay there, but it's not considered a gift.
Right. At that point, they'll have the full credit and everything too, once they're resident.
It's a great vehicle.
Yeah, we do use this quite a bit. Yeah, so here are the disadvantages and advantages of the GRAT. Basically, there's very little disadvantages if grandpa or grandma just wants money every month. The QPERT is incredible. Honestly, it's a great way to get the house out. Oftentimes, the house is very valuable. Please let us know if you have any questions. Call us or email us. And if you would like a copy of any of our books, same thing, just send us an email. Thanks so much for attending today.
Help, if you've got a question, want to discuss a matter, just reach out to me on my at globaltaxfocus@gmail.com, and we'll arrange a time to have a conversation.